Thanks, Sam. And thanks to all of you for joining in today. You know, I have a very vivid memory of the first time as a banking attorney that I got a call from a banker who had an IRS agent in the lobby asking for copies of a customer's records. And the person within the bank who normally handled subpoenas, summons, search warrants, and the like was on vacation. And the person that I was speaking to was a little bit panicked. I don't think anybody would disagree with the notion that IRS agents can be pretty intimidating. And when you have one there who is asserting that he has a legal right to immediately demand certain customer records, you feel like you'd better be very, very certain of the legal ground that you're standing on before you either give out the records or say, no, I'm sorry, you have not used the right approach. You don't have the legal basis that you need, and you're going to have to make the request through different means. And it was that request years ago that motivated me to get up to my eyeballs in the privacy laws, because I know that these matters are time sensitive. So when you get something like this, you don't have a long fuse for you to use to make a decision about what way to proceed. You need to know what the basics are and where to look for the particulars. So today we're going to go through and we're going to talk about what the avenues are that you might see for somebody trying to get a hold of customer information or customer records, and what the legal concepts are that you'll need to be following, and some of the specific law. If you think about your customers' financial records, they tell so much about the individual. They can tell how much the person's spending on groceries, what magazines they have subscriptions to, how big their mortgage payment is, all kinds of things. So it's no surprise that there is a lot of evidentiary value in those financial records. And whether you have a dispute between business owners and they're suing each other, or spouses, or you have the SEC investigating someone for possible insider trading, or you have the IRS looking at a delinquent taxpayer, or you have the Small Business Administration that's looking to see if somebody has done something that violates the terms of a loan agreement they have. It's not difficult to imagine how valuable financial records could prove in both civil and criminal cases. So what we find with the law is it tries to do a balancing act, because there are, in some instances, a legitimate need for the government or even private parties to be able to have access to financial information. But on the other hand, all of us want to feel that we are secure in our records, that our financial matters will remain confidential. And in most instances, that's certainly going to be the case. But the law steps in and it says, okay, there are some circumstances where the legitimate need of the government or a private party outweighs the customer's desire for confidentiality. So understanding when that is the case, when the government or a private party can have access to your customers' records is essential because you're the gatekeeper. When somebody wants access to your customers' information, you're the one that is standing between them and that confidential information. And the expression, you can't put toothpaste back in a tube, the same kind of concept applies here. Once you've given out the records, the harm is done. It's not like a case where you make a mistake responding to a garnishment, and let's say the bank receives a garnishment on Joe Smith, and the bank accidentally takes the funds from the wrong account. In that instance, the harm is quantifiable, and to a certain extent, the harm is repairable, because the bank then goes back and they make the Joe Smith, whose account was raided, whole by giving him back his money and perhaps some interest, or compensating him for any other actual damages that he suffers. But once financial information has been given out, what has been seen can't be unseen, and it may give someone access to things that they shouldn't have. So making sure that as the gatekeeper, you do the right thing is imperative. Your reputation as a financial institution depends upon that. So your goal is to protect your customers' privacy, but at the same time, when you receive records requests that the law says you have to respond to, your goal is to comply with the records request in the proper way within the appropriate time period. There are some things that you're going to be able to do to protect secondary parties, such as joint account holders, and you should have as a goal minimizing the harm to third parties. And then you also don't want to have lawyers abuse your financial institution. And in that regard, you may receive from time to time some subpoenas that are not well drawn. They think that whatever whatever they're looking for is in there somewhere in your bank. They don't know exactly where, so they're just going to describe everything they can possibly think of. And I'm here to tell you that when you get something like that, you don't have to just roll over and respond. Even if it is an otherwise legitimate request that has followed the proper procedures, there are avenues that you can take to protect you against subpoenas, summons, and search warrants that are overly broad and unduly burdensome. So we're going to examine that aspect of financial privacy as well. So we're going to begin by understanding some of the basic tenets of financial privacy laws and cases. One of the most important things we're going to do, however, is teach you what questions you need to ask when you get served with a subpoena or a summons or search warrant. There's a very systematic way that you will go through these things in order to draw your conclusion about what law applies and what your legal responsibility is and what you need to do and when you need to do it. We also want you to be aware of what's referred to as common law privacy protections. And there, what we're talking about